Hi everyone. So we are going to study about the subject corporate law, and the topics are navigating insolvency and bankruptcy, and also we will study five important definitions based on insolvency and bankruptcy. So as an introduction, the Insolvency and Bankruptcy Code (IBC) 2016 streamlines financial distress resolutions for businesses and individuals in India. It aims to provide a faster, more efficient, and fair process for all parties involved, replacing previous fragmented laws. This presentation will cover the main goals of IBC, key terms, and the roles of adjudicating authorities. So the first topic is main goals of IBC. Now let's talk about the key goals of IBC. Can anyone guess what the primary objective might be? First one is quick resolution. The IBC emphasizes resolving insolvency cases in a time-bound manner to prevent prolonged financial instabilities. And the second one is creditor protection. Imagine if you're a supplier who hasn't been paid. The IBC ensures creditors like you have a fair opportunity to recover dues. The third one is business revival. Instead of immediately shutting down the struggling company, the IBC prioritizes effort to restore financial health wherever possible. And the last one is financial discipline. The IBC encourages business to manage their financial responsibly, reducing defaults and promoting accountability. So the next slide is based on financial creditors defined. This topic comes under five important definitions under insolvency and bankruptcy. So here's a question for you. Who do you think has a stronger influence during insolvency proceedings? A bank that give a loan or a supplier awaiting payments? Financial creditors like banks, bondholders, or financial institutions are key decision makers in Committee of Creditors, means COC. It is defined as COC because they typically have more at stake. And for an example, just imagine a bank lending rupees 5 crore to a company. If that company defaults, the bank can file for insolvency under the IBC framework. So the next topic is operational creditors defined. It is the second important definition in the topic. Now let's look at the operational creditors. Those owed money for goods, services, or wages. Can you think of any examples? So the examples are suppliers, employees, and the government authorities. While operational creditors can file for insolvency, they typically do not have voting rights in the COC, giving the financial creditors more influence in the decision making. So the next topic is understanding the moratorium. Here is an interesting one. What do you think happens when an insolvency proceeding starts? Are debt collectors still allowed to knock the door of the company? No, they aren't. When insolvency proceeding begins, the IBC imposes a moratorium, a legal pause that temporarily holds recovery action or legal proceedings. This allows breathing room to explore a resolution plan with external pressure. During this period, no lawsuits can proceed against the company. The company is restricted from transferring or selling its asset. This protection generally lasts up to 180 days or extended up to 330 days if needed. So the next topic is corporate insolvency resolution process, means CIRP. Now let's break down the CIRP, the structured process that helps resolve insolvency. Can anyone tell me what's the first step in starting this process? There are four processes. So the first one is initiation. An application is filled with the NCLT by the financial creditors, operational creditor, or the company itself. And the second one is appointment. An interim resolution professional (IRP) takes over management. And the third one is COC formation. COC means Committee of Creditors. Financial creditors form the Committee of Creditors to decide the company's fate. And the last one is resolution or liquidation. The COC may approve a resolution plan or, if none is viable, or for the liquidation. So the next topic is adjudicating authorities, the NCLT and the NCLAT. Here's a question for you. Who decide the fate for the insolvency cases? The National Company Law Tribunal, the NCLT, oversees the cases, approves resolution plans, and issue liquidation orders. If anyone disagree with the NCLT decision, they can appeal to the National Company Law Appellate Tribunal, the NCLAT, and in some cases, it even can go to the Supreme Court. So we have covered all main five topics under insolvency and bankruptcy. Now let's see some real life examples with IBC played a key role. The first one is Jet Airways case. In this case, NCLT guided the resolution process, ensure fair treatment of creditors and the stakeholders. And the second one is Isar Steel case. The major insolvency case went from the NCLT to the Supreme Court, showcasing the complexity and significance of IBC framework. Before concluding, I would like to put up a question for you. In a rapidly evolving business environment, how can a company proactively manage their finance to avoid insolvency in the first place? So, as we move to the end of the presentation, I would like to conclude that the Insolvency and the Bankruptcy Code IBC 2016 is a crucial law for managing financial distress in India. It ensures that struggling companies are either revived or liquidating fairly and efficiently. By providing a clear process, the IBC protects creditors' rights, promotes business stability, and strengthens the economy. So this is Shiv Prasadar. Thanking you all for watching the video till the end. Hope to come again with another interesting presentation. Thank you.